Picture this. You've been waiting for your green card for 5 years, checking your mailbox every single day, refreshing the USCIS website every morning, and living in constant uncertainty about your future in America. Then suddenly, everything changes. The rules shift, the timelines accelerate, and opportunities you never thought possible become reality. Well, that moment is here. USCIS just dropped 8 absolutely massive policy changes that are going to reshape the entire landscape of employment-based immigration in America. Whether you're on an H-1-B visa, you filed an I-485 adjustment of status application, or you're somewhere in the green card pipeline, what you're about to learn in this video could be the difference between years of waiting and finally achieving your immigration goals. And I'm telling you right now, the 7th change on this list is something almost no one saw coming, and it's going to blow your mind. So let's jump right in. Hey everyone, welcome back. And if this is your first time here, you've come to exactly the right place, because we cut through the confusion and give you straightforward, practical immigration information that actually helps you make better decisions. Now, before we get into the details of these 8 transformative changes, do me a quick favor and smash that subscribe button and hit the notification bell, because immigration law changes constantly, and the only way to protect yourself and your family is to stay ahead of the curve. I promise you, missing the next update could cost you months or even years in your immigration journey. All right, let's break down exactly what USCIS announced and why it matters so much to you. Starting with the first bombshell announcement, premium processing is expanding in ways we've never seen before. Until now, premium processing has been available for certain petition types, giving you a guaranteed 15-day processing window for an additional fee. But here's what's changing. Beginning in the first quarter of 2026, USCIS will extend premium processing availability to I-140 immigrant petitions across EB2 and EB3 employment-based categories. Now, if you understand the green card process, you know the I-140 approval is a critical milestone. Everything else hinges on it. For years, applicants have endured 8 months, 12 months, sometimes 18 months of agonizing wait times just for this one approval. Imagine cutting that down to 15 days. You get certainty, you can plan your life, and you can move forward with the next steps in your immigration process almost immediately. For someone who's been in limbo, unable to make major life decisions like buying a house, getting married, or changing jobs, this change represents freedom and control over your own timeline. Moving to the second groundbreaking update, domestic H-1-B visa renewal is finally becoming a reality. This is something the immigration community has begged for, and it's actually happening. USCIS, working together with the Department of State, is launching a pilot program that allows H-1-B visa holders to renew their visa stamps without leaving the United States. Let me paint the picture of why this is so important. Under the current system, when your visa stamp expires, you have no choice but to book expensive flights back to your home country, schedule a visa interview at a U.S. consulate, which might have wait times of several months, attend that interview, and then wait nervously hoping you don't get stuck. In administrative processing, I personally know people who've been separated from their families for 2 months, 3 months, unable to return to their jobs in the U.S. because of processing delays. The new domestic renewal program eliminates all of that nightmare. You submit your renewal application right here in the United States, and you receive your stamped visa by mail. The pilot program will begin in the middle of 2026 with approximately 50,000 available slots. If you hold an H-1B visa, you need to be ready when this program opens because those slots will fill up incredibly fast. The convenience, cost savings, and peace of mind this provides cannot be overstated. The third major development tackles a heart-wrenching problem that has torn families apart, children aging out during the green card process. Under the new USCIS guidelines implementing the Child Status Protection Act, there are expanded protections for derivative beneficiaries. Here's the nightmare scenario this fixes. A parent files for an employment-based green card when their daughter is 17 years old. The process drags on due to country-specific backlogs and processing delays. 5 years later, when the priority date finally becomes current, the daughter is now 22 years old. Under strict interpretations, she's aged out, lost her derivative status, and faces potential deportation or must find her own immigration path. Families have been destroyed by this. The new guidance provides more favorable calculation methods and clearer standards that will protect significantly more children from aging out. It takes into account processing delays that are beyond the family's control. For parents who've been living with the fear that their children might be forced to leave the country after growing up in America, this change brings hope and protection. Now let's talk about the fourth transformation, which centers on I-485 adjustment of status applications and work authorization. USCIS has made a public commitment to reduce I-485 processing times by 30% within the next 24 months. They're achieving this through hiring additional officers, implementing better case management technology, and eliminating redundant procedural steps. But the real game changer here is the automatic employment authorization document extension. Right now, if you're adjusting status and your EAD is about to expire, you have to file a renewal, pay the fees, wait months for the new card, and you might experience gaps where you legally cannot work. It's terrifying for people who are the sole breadwinners for their families. Under the new policy, if you've timely filed your EAD renewal and your I-485 is still pending, your work authorization automatically extends for up to 12 months. You get a receipt notice that serves as proof of continued work authorization. No gaps, no panic, no lost income. This single change will reduce stress for literally hundreds of thousands of people who are waiting for their green cards. Here comes change number 5, and this one is absolutely massive for people stuck in employment-based backlogs. USCIS is creating what they're calling a provisional bridge status for individuals with long pending priority dates. This is specifically designed to help applicants from countries with severe backlogs, primarily India and China in the EB2 and EB3 categories, where people are facing 20-year waits or longer. Here's how it works. If your I-140 has been approved for more than 5 years and you remain in valid status, you become eligible for this provisional designation. What do you get? First, work authorization that is completely portable between employers. You're no longer chained to one company out of fear of losing your green card progress. Second, international travel becomes much simpler without the complications of advance parole. Third, your spouse gains unrestricted work authorization. Fourth, your children receive protection against aging out. You don't get the actual green card yet, but you get many of the practical benefits and the freedom to live your life. For families who've spent a decade or more in uncertainty, unable to take career opportunities or make basic life choices, this provisional status is genuinely transformative. The sixth update revolutionizes biometrics and interview requirements through a smarter, more efficient approach. USCIS is dramatically expanding their biometrics reuse policy. If you've provided fingerprints and biographical data within the past 5 years for any USCIS application, they may waive the requirement for you to appear for another biometrics appointment. No more taking time off work, driving to application support centers, sitting in waiting rooms. Your existing biometrics get reused. Additionally, USCIS is implementing risk-based interview scheduling for I-485 applications. Straightforward cases where all documentation is complete, backgrounds are clear, and there are no complications may be approved without an interview. Complex cases still get full scrutiny. This isn't about cutting corners on security, it's about being smart with resources. Why force every single applicant through identical steps when some cases clearly need more attention than others? This change means faster approvals for routine cases and more officer time dedicated to cases that actually need careful review. Change number 7 addresses one of the most frustrating sources of H1-B denials: unclear specialty occupation standards. USCIS has released comprehensive updated guidance that clearly defines what qualifies as a specialty occupation with concrete examples across dozens of industries. They're acknowledging modern work realities, including remote positions, hybrid roles, and jobs that didn't exist 10 years ago. Technology roles, healthcare positions, business analyst jobs, all of these now have clearer standards and definitions. The guidance also tackles the thorny issue of third-party placements, providing specific criteria for when these arrangements are acceptable. For H-1B employers and workers, this means fewer surprise requests for evidence, fewer arbitrary denials, and much more predictability in the petition process. When you know the rules clearly, you can prepare better documentation up front and avoid costly delays and denials. The eighth and final major change involves fee structures and payment systems. Yes, some USCIS fees are increasing, but here's what's different this time. USCIS is implementing income-based fee reductions for qualifying applicants, installment payment plans for large fee amounts, and a complete transparency system where you can see exactly how your fees are being spent and what service improvements result from fee increases. They're also creating automatic fee waiver determinations based on income thresholds, so eligible applicants don't have to go through complicated waiver application processes. This acknowledges a basic truth. Immigration fees have become prohibitively expensive for many families, and if we want a functioning immigration system, it needs to be financially accessible while also being properly funded. So what should you do with all this information? First, if you have pending applications, review them immediately with your immigration attorney to see if any of these new policies create opportunities you should pursue. Second, if you've been delaying filing because of long processing times or uncertainty, these changes might make this the right moment to move forward. Third, stay vigilant because implementation of new policies always comes with growing pains and complications. You need to monitor your case, respond quickly to any requests, and advocate for yourself. These 8 changes represent the most significant positive movement in employment-based immigration policy in years, but they only help you if you know about them and take action. If this video helped clarify these complex changes, show some love by hitting that like button and sharing this with anyone navigating the immigration system. Drop a comment telling me which change impacts your situation the most, because I read every single one and your feedback shapes the content I create. Make sure you're subscribed with notifications on because I'll be releasing detailed follow-up videos on each of these policy changes with specific action steps and timelines. Your American dream matters, your family's future matters, and you deserve an immigration system that works. These changes are proof that progress is possible. I'm here to help you understand every step. Until next time, stay informed, stay proactive, and keep pushing forward toward your goals.